I just want to make sure I understand. You're alleging that the Southern Poverty Law Center was paying the leaders of KKK and other groups to continue their operations? Is that?
I'm not alleging it. The grand jury returned an indictment that says that. And so what the investigation found, according to the indictment that was returned today, is that they were paying. So the Southern Poverty Law Center is raising money, asking folks to give them money to dismantle racism. And over a very long period of time, they were using some of the money they raised from donors to pay to, they call them field, basically to informants, for information, for access, to just pay them for certain, to do certain things. And so, yes, that's exactly what the indictment charges.
Mr. Acting Attorney General, how did they get away with this for so long?
I mean, it's a great question. I said today during the press conference that we know that this investigation was opened during the Biden administration and then mysteriously closed. I really don't have any information about why it was closed. And then we started again last year, the FBI did, working with the U.S. Attorney in Alabama. And it's extraordinarily egregious. You just talked about it. But imagine a donor to the SPLC if they were told, by the way, we're going to give the money you're giving us to the Ku Klux Klan. Okay? Like, it's in some cases over $1 million. I mean, it's incredible.
Now, they say they're no longer using these informants in this way and that it was necessary because they had all sorts of threats against the organization, firebombing threats and other acts of purported violence. And that's why they had to use these informants. And to that, you say?
Well, to that, I say, for one, the indictment charges all the way through 2023. So I'm here to speak about what they're doing right now, but that indictment charges a long period of time through 2023. And second, and more importantly, there's no allegation or information in the indictment that suggests they shared that information with law enforcement. They have communicated.
They said they did.
Well, they have communicated when they so chose with law enforcement over the years. There's no information that we have that suggests that the money that they were paying to these informants and these members of these organizations, they then turned around and shared what they learned with law enforcement. To the contrary, or else we would have known from their own words that they had given this money to these guys, and we didn't know it.
To all units, proceed to your post assignments. All units, proceed to your post assignments.
That's the sound of the police. Whoop, whoop. That's the sound of the beast.
Yeah, baby, it's episode 29 of Probable Cause on April 28th, 2026. Jeff Norman, a.k.a. America's Sweetheart, with you, as I always am, and so is my beloved co-host, the FBI whistleblower, Greg Dillon, with rosy cheeks, very well-centered, between his two green lamps and matching green shirt. A belated happy St. Patrick's Day to you, sir.
Why, thank you, sir.
Well, today we interviewed Bill Shipley, who's known far and wide as Shipwreckedcrew. He's a former federal prosecutor, and he's been in private practice, I guess, for about 9 years since he left DOJ. And he was unable to be with us live, so that's why we recorded it. Last Thursday on The Whiners, we had Kevin Lynn on, who is the executive director of a nonprofit that was smeared by the Southern Poverty Law Center. And we had a good time saying how we hate that organization. We didn't hide our bias at all. And we told some anecdotes about, how they've harmed people with their hate groups. They're very big on the word hate. Mm-hmm. But today we were much more sober. I don't think our bias got in the way at all. And Bill gave us as I say, very sober analysis of what this case is about, wouldn't you say?
Yes. One thing that came to mind, and then we can get back into Mr. Shipley. When I was watching that interview for the second time, it struck me, and I like that Todd, is it Blanchard? Right? Blanche. Todd Blanche. I like him. I think he's a solid choice. But when you get up there and you're the head of the organization, and you said that the investigation was opened by the Biden administration Attorney General's office. And then, oh, why, thank you. And then you turn around and say, well, we don't understand why it was closed. I don't like that answer. The file is going to contain some closing document, some memorandum to the file as to the circumstances and reasoning behind why the file is closed. You just don't snap it shut and put it back on the shelf, and that's the end of it. There has to be some documentation as to why you felt it would not be a successful prosecution or a viable prosecution. I don't like him sitting there and saying, I don't know why the investigation was closed. Of course, you know why the investigation was closed. You have all those documents in your possession. You need to review them.
Well, I didn't think you were going to go there. You threw a monkey wrench at me. Is that the saying? So here's what I have to say. Two things I have to say about that. One is he very well could deserve this criticism that you're leveling at him, that he's being evasive, less than straightforward. But isn't it also possible that what you're just talking about is what's supposed to happen? Is it not possible that whatever they put in the files was not sufficient, not normal in terms of explaining why they closed it?
I guess it could be. I mean, usually there's a protocol for opening and closing files, and I would be very, very surprised or shocked that if that procedure was not followed, especially on a case of that significance. And I don't like him saying he has no idea when he's in charge of the department.
All right. We're getting messages that my volume is lower than yours. So I just brought Greg down. Does that even it off? Say something, Greg.
Yes, I think that's probably better.
How is that, Helen? Or do I need to bring myself up more? I could do that. What do you say, Helen? Thank you for your help. It's so hard to get this volume.
Well, I think sometimes when I get a little excited, my voice goes up a little bit and louder, and then maybe levels off later on. But I just had to get that off my chest. But I don't want to take away from Mr. Shipley's time.
Look at Helen. She's telling you how good you look. She's also complimenting you on the quality of your question, and she's also helping us get our volume straight. I think Helen may get the MVP word. She's saying my volume has to go up. Okay, you talked me into it. I will do that. What do you make of them apples? Hang on a second. Edit mic settings. All right, Helen, how's that? Am I up as loud as I should be now? 1, 2, 3, 4, 5. Am I about equal with Greg? Well, anyway, we're not going to be talking too much for a while.
Yep.
We're going to play this interview that we recorded earlier today. I think we'll be able to insert thank you, Helen. I think we'll be able to insert the comments live that come in during it. And then after the recorded interview, Greg and I will come back on live and we'll do Has It Happened to Greg, maybe take phone calls, whatever you guys might want to do. So in addition to this issue of the Southern Poverty Law Center indictment, we also talked to Bill about a recent Supreme Court decision. They didn't even hear the case. I think they called it a summary judgment. It was about what the police need to meet the requirement of reasonable suspicion when they stop somebody on the street. I thought of you when I saw that in the news, and I thought we got to get down to the bottom of this. That didn't sound right at all. And then we also talked a little bit with Bill about the White House Correspondents' Dinner shooting the other night. Maybe you heard about that. There was a shooting. Although perhaps some of you in the audience, like Stefan, might insist it was a false flag. Maybe the shooting never happened. It was all staged with actors. That's what some are saying. I don't know. All right. Anyway, let's play that interview with Bill Shipley. Again, the Southern Poverty Law Center was indicted earlier this month by a federal grand jury on wire fraud, bank fraud, and conspiracy to commit money laundering charges. And here's how the acting Attorney General Todd Blanche sums up the gist of what's wrong here.
But what we do know is that the very entities that this group was raising money to go against are the very entities that they were taking the money in and paying to these entities and these individuals associated with those groups.
He's referring to the fact that their mission is to fight racial injustice, and they were giving money to people at these in hate groups. Actually, these are the very groups that they have deemed hate groups. So here now is the interview with Bill Shipley, aka Shipwrecked Crew. So how common is it for charities to pay informants? Is that in and of itself illegal, or it could be legal depending on the circumstances?
Well, as for a charity, it's basically unheard of. The charitable provision under the IRS code, commonly referred to 501c3, has very limited purposes, very limited functions that are recognized as legitimate, nonprofit, tax-exempt operations. Charity is one. Educational is another. That's what the SPLC is going to claim, is they're an educational organization, and that this is an information gathering process, and this is simply a means of gathering information. But that's not what the crime is. The crime isn't using informants to gather information, paid or unpaid. The alleged crime is not disclosing that donor money would be used in that fashion to the donors. The government's characterization is that by perpetuating racism, the SPLC had a reason to continue on in its operations, and that those operations from the standpoint of fundraising were highly lucrative, tens if not hundreds of millions of dollars over the lifetime of the SPLC, which stretches back to 1971. So it's, I wrote not too long ago that racism, so to speak, for the SPLC is the goose that lays the golden eggs. It gives it a reason to exist.
Right.
And I'm not saying that anybody connected to the SPLC is walking in Elon Musk's shoes today as a result of, this quite lucrative business model. But you can pay a lot of high six-figure salaries over a long period of time to SPLC employees and officials if you are bringing in, tens of millions of dollars a year in donor money. So it's personally lucrative in the sense that it's job security and a very substantial annual income for those who work for the SPLC.
Well, charities don't typically disclose how they spend their money, like they don't itemize all their expenditures. So what makes it required to disclose this particular expenditure? And if they had disclosed it, would it have been lawful?
Well, they could have disclosed how they spent money, and there has been nothing unlawful about that. But charities do have an obligation to disclose their charitable purposes and their charitable endeavors, because charities, legitimate 501c3 charities, have an obligation to file tax returns, not just with the IRS, but they have to file tax returns in all 50 states where they raise money, or in all states where they raise money, presumably 50 states, because not only are they a nonprofit, for a legitimate 501c3 organization, the donor's contributions are tax deductible. So the taxpayer, so to speak, is contributing in two ways: by having the donor not pay taxes into the Treasury, and having the revenue received and then paid out again by the 501c3 not have to pay taxes. So you're involving the Treasury and taxpayers in the exercise by operating as a 501c3.
So is the obligation to disclose it to the donors or disclose it to the IRS, or both? And did they must have put something on their tax forms to account for the expenditures?
Okay, well, I'm not a tax expert, so the extent and specificity of obligations to disclose charitable purposes and endeavors to the IRS is, not a road I want to go down. But with respect to making a material omission, and that's what this is, the material omission, a material omission, failure to disclose information to a donor, the wire fraud, bank fraud, mail fraud statutes have essentially two necessary components with regard to an omission: a duty to disclose in some fashion, as well as an intent to deceive by failure to disclose. So simply not disclosing is not a problem if you have no duty to disclose. Well, 501c3, the donor's tax deductibility of their contribution rides on the money being used in an appropriate manner. If the money is not used in an appropriate manner, it calls into question the 501c3 status and the tax deductibility of the money the donor has already parted with. So I think it is not a stretch to say there is a duty owed to donors to use their money in appropriate methods. An intent to deceive, this is where the left wing is trying to defend the SPLC. They're trying to say, well, there's no intent to deceive because even if they had told their donors, the donors wouldn't object it. It was simply a means to an end. Okay? Problem with that is it's an objective test. It's not a subjective test. The test is not what would SPLC donors have decided to do if this disclosure had been made. The test is what would a reasonable person consider meaningful information when deciding to part with their money. And at the end of the day, that's a question for the jury. And, I often had these kinds of cases as a prosecutor where it was, well, yeah, I know it looks bad. Yeah, I know my conduct seems to fit all the elements of a crime, but let me explain to you why I did what I did. The answer to that is always the same. You can explain it to the jury.
Right. Yeah,
once the elements of the crime are established by the evidence that the government's gathered, it's the yeah, but doesn't factor into the charging decision.
Yeah. Well, that's what I want to get at is what they have to prove in court. Because I can tell you for sure that I can't stand this organization. I would love for them to go out of business. But by the same token, I want it to be, I want justice to be served. I want to really understand what the law is. It seems to me like it's more about, or it should be more about whether or not it was legitimate to pay all the money they paid and how it was used than about disclosure. I mean, I might be wrong. I'm just trying to envision like your typical nonprofit website. If you look at it, it doesn't say very much at all about how the money's going to be spent. So that's the part I'm having trouble with is like, how is this disclosure supposed to have been made? And, what if they spent too much money on advertising or, all the different things that nonprofits pay? I don't know of any way that that's typically disclosed.
Again, you are confusing a nonprofit with a 501c3 charity. The charity is a much narrower exception, and SPLC is a 501c3. The world's full of nonprofits. You just don't have to have a profit motive. You don't have to register a nonprofit.
Well, I'm using that term synonymously when I say a nonprofit.
They are not synonymous. They are not synonymous. A 501c3, you can have what's called a 501c4, social welfare organization, that is a nonprofit, but contributions to it are not tax deductible. Let me give you an example. Little League, youth Little League sports. They don't operate on a profit basis. The local league that's being operated by a bunch of moms and dads, they're not putting money in the bank as a profit, but they're not a charity either. So they're not doing charitable work. So contributions to Little League are not tax deductible, but it is still a nonprofit recognized by the IRS. You do not have to register officially to be a nonprofit if you simply establish that you do not operate on a for-profit basis. But a 501c3 charity is different. They have
I get the distinction, but the same question though. If I go to the website of a 501c3, I don't typically see a list of how they're spending all their money.
Well, the government has put in, in the indictment, some limited information just to establish that the SPLC has made representations about how they would use donor money, and they have not disclosed that they are using donor money to pay people inside racist organizations, not just for information. That's the problem. This is the claim being made, that they made it just to accumulate information, just for educational purposes, but not when you're promoting, telling somebody to transport individuals. take our money and use it to transport racists to Charlottesville so that we can increase the chances of a violent clash, and then fundraise behind it. I saw one, I don't know if this is accurate, I'm just something I read, but there was a juxtaposition of the $270,000 that they have alleged to have paid one of the Charlottesville organizers. And
unite the right. Yeah.
Right. And that in the aftermath of Charlottesville, they raised more than $10 million in donations.
Right.
Okay. So now, but let me make another point. This is why we can go on and discuss, as long as you want, what the evidence might be. We have no idea. We have no idea what documentary information the government has acquired through grand jury subpoenas or search warrants. Communications internal among people of the SPLC, communications between the SPLC handlers and these informants. Who knows how open and obvious they have been about discussing this, because for 40 years, they didn't think it was a problem. Okay? And we have no idea who in the SPLC has maybe already been interviewed and has already talked. I think there's strong suggestions in the indictment that has happened. And that because the indictment goes out of its way, in my view, and I've written a lot of indictments like this, and oftentimes the strategy in drafting an indictment is to say only what's necessary and no more. Because the more you say, the more you're conveying to the target what you already know about them in a circumstance where the investigation is ongoing. It should not be lost on anybody that only the SPLC is named here. No individuals are yet named. Some individuals operated this program. The SPLC as an entity didn't do this by itself. But we know who some of the people are. We don't know them by name, but their titles used in connection with. I saw some of the legal beagles on X who were trying to diminish the significance of this lawsuit, saying, well, no individuals were named, but they didn't really say what the significance of that is, and I was left wondering. So what is the significance of the fact that no individuals have been named? No individuals have been named yet. Yeah, right. So what does that mean? What does that mean? Because if you were to name somebody, that person might be able to say, the only person who knows I did X, Y, and Z is Joe Schmo. Well, now he knows that Joe Schmo has talked to the government. Okay? It's a mechanism by which the more you put in, the more the defense lawyers and the defendants have an understanding of where your information is coming from. And right now,
Bill, this would be like an organized crime case to a degree, right? A Cosa Nostra case out of New York where you do not want to compromise your sources until you absolutely have to?
Correct. And let me give you a great example, because this was something that I did a lot of. I had developed a little bit of expertise in it. The fact that they've only charged a money laundering conspiracy and no money laundering counts. Okay, money laundering conspiracy simply means two or more people agreed to launder money. It doesn't tell you anything about who that might have been. Because a money laundering conspiracy, unlike other conspiracies, the law does not require the allegation of an overt act. Well, when you start putting in overt acts, how much money was deposited in a particular institution on a particular date, those details begin to narrow the crowd of individuals who might have conducted that transaction. So when you put specific transactions in, you're once again providing information to the other side about who might be talking, because a limited number of people knew about the transaction. So the fact that there are certainly dozens, if not more, money laundering transactions or alleged money laundering transactions that could have been included in the indictment, because they've got all these transactions of sending money to the various informants. Every one of those transactions, on the theory made by the government, the theory proposed, every one of those transactions is a potential laundering transaction. So if you start putting in particular transactions, you begin to convey information to the defense that they don't yet have. So instead of doing that, you start with just the conspiracy, which you can name SPLC and others known and unknown to the grand jury. That's all you need.
Bill, I had a question when I was reading about this case. They cited a specific example, and it didn't get a lot of play, but they mentioned that at one point an informant was paid to essentially commit a burglary and remove a cache of documents.
Right.
And then at some point, they decided they were going to, I guess, commit a second burglary to replace those same documents after they've been photocopied. I never hear the term used very much, but misprison of a felony, right? It's still a legitimate federal charge, is it not?
18 U.S.C. Section 4, I think.
Look at you go. I wouldn't be able to come up with that in 100 years. But my point is...
let me tell you why real quick. Because on occasion, we would oftentimes allow the girlfriend to plead to a misprison of a felony in exchange for their testimony against the drug dealer boyfriend.
Oh.
Because misprison of felony is simply the failure to report to law enforcement information about a felony that you were involved in or aware of.
Correct.
So we would use it to resolve cases against the significant other of the drug dealer.
But I'm just curious why that has not been applied where you have a felony, a burglary taking place on two occasions. Regardless of what the intent of the burglary was, a civilian still does not have the get a pass on it.
Right. It's a charge that's almost never applied. Like the example I just gave, that was a way to resolve a case.
Yes.
That was the plea bargain. Rather you might have charged the girlfriend with actually being involved in the distribution of drugs. And to resolve her case, I think the misprison has a 2-year statutory maximum. So you could tell them, look, you're going to get sentenced, you're going to get eviction, it's going to be a felony, you're going to get sentenced, but the maximum you get is 2 years. Well, I think that allegation, I don't know, it's only a guess, I think that allegation in the indictment is simply to establish that the SPLC was willing to engage in lawbreaking with its informants.
But I'm just curious why it wasn't a tailored charge of conspiracy to commit burglary and misprison of a felony. If you stack the charges, it does carry some weight, and I think it gives you some leverage. So I don't understand why that kind of was just apparently looks like it was overlooked or dismissed.
Well, you could come back along, and whoever was paid to do that could plead guilty, and to misprison. Even though they'd engaged in it, they could plead guilty to misprison as disposition in their case, and then they cooperate against whoever it was that paid them to do that.
Okay. All right. Thank you.
This whole notion of committing a crime for the purpose of getting somebody else, to catching somebody else committing a crime is something I've been curious about. I remember in the David Letterman case, in that when it was sort of an extortion case in New York, when somebody had information about Letterman having an extramarital affair, and the DA and Letterman's attorney got together and gave this guy a bad check for $1 million, I think it was. And I always wondered, what makes it legal for Letterman's attorney to write a phony check? And what if the guy had been acquitted? Wouldn't Letterman or his attorney have then been liable? Do you follow what I'm saying?
No. It's a very simple concept. It's existed, forever, for lack of a better description. If law enforcement authorizes you to take action that's criminal, and you do it on their instruction, you don't have criminal intent. You're not doing it to commit a crime. You're doing it to help an investigation by appearing to commit a crime. So you lack criminal intent to be prosecuted for. Two private parties can't do that. One private actor can't tell another private actor to commit a crime and as a result eliminate the criminal intent on the part of the private actor. Only law enforcement can do that.
Yeah, I mean, my recollection was we always had to apply for a warrant if we were going to surreptitiously set up an eavesdropping or a surveillance camera or microphone inside of a residence or a business, but you did it with pre-authorized court approval.
Right.
But I don't understand how they get a pass on basically doing the same thing with no, not being legally sanctioned to do it.
Well, again, though, this is just the first indictment. All of this may be tied up in a. I can't say right now why they chose to roll this out at this stage with just the SPLC named.
Mm-hmm.
It could conceivably be that if it's done to demonstrate to people who were wavering about whether they should cooperate or not.
Okay.
It's like, so it's an expression that I often used as a prosecutor when talking to a reluctant cooperator, somebody who might have been involved in the criminal.
I think I know where this is going to go. Go ahead.
It's like, well, the phrase is, this train's leaving the station. You're either on it or you're getting in front of it, getting run over. So you have to decide.
Yeah, so we used to have the one, the first person on the bus gets the best seat.
Yeah. So, so by rolling out this indictment and laying out sort of the bare bones nature of what the criminal allegations are, you are trying to encourage people to get on the train rather than stand on the tracks.
Right. So you mentioned that, we don't know what the evidence is. And of course, that's something we should keep in mind. But let's get at a little bit the type of evidence that probably is going to be relevant in this case. So it seems to me like did the Southern Poverty Law Center get for its money is a key question. One answer to that question is they got a lot of donations. Are they going to also have to try to show that there was a more legitimate purpose? In others, are they going to have to show some evidence that they got some information that was then used in a way that might arguably be consistent with their charitable purpose?
Again, though, that doesn't save them. That's not a defense to not disclosing what is material information as part of your efforts to raise money. The fact that you did good with some of it isn't a defense to the fact that you didn't disclose you were going to do bad with other parts of it. And again, this idea that it's all about simply gathering data, that's a smokescreen. The government would not have prosecuted this case if it was just about gathering data. The government prosecuted this case, or is prosecuting this case, because the payments were intended, and again, this is where we have to wait to see what kind of communications they have. The payments were intended to promote the actual violence for fundraising purposes that they said they were attempting to eliminate by dismantling the organizations.
Bill,
So
I know I'm probably older than you, and you're probably older than Jeff, but if you recall the Three Stooges, which I used to watch growing up, and they posed as they brought mice and ants into a rich person's house in secret, and then they came back as exterminators and knocking on the door to see if they needed their services. And as soon as I was reading the indictment, that's all I could think of immediately was that comedy skit where they brought in the vermin and then they showed up to help eliminate the vermin.
Exactly, but what would add to it is like when you show the basket of vermin that you eliminated, you at the same time leave more behind. That sort of, by promoting these organizations, by giving them operating funds. I have no idea how much it actually cost to, for the organizers to bring about the Unite the Right March in Charlottesville. What if it was only $500,000 and SPLC provided more than half of that? They provided it. I'm actually coming around to the view that the SPLC, obviously, they didn't want the informant. Well, I suspect that the SPLC didn't want the informants to know the money was coming from the SPLC. That's why they use these cutouts, the banks and whatnot, is so that somebody, an intermediary, could contact the members of these organizations and say, hey, I got somebody who wants to donate money to you guys.
Some wealthy donor that supports the cause.
Right. And the cutouts were to prevent the KKK or neo-Nazi or whoever from knowing that the money was actually coming from the SPLC, because that would have caused am I being set up? The first reaction would have been, am I being set up by you guys?
Or they could turn around and try to blackmail them into giving them additional money to keep their mouth shut.
Keep their mouth shut. So now, and again, we don't know all the evidence. The little bit that I've been able to sort of piece together, though, apparently at some point after they closed those bank accounts, they started making ACH transactions, which is just like Venmo and PayPal and stuff like that, where one bank just moves money to another bank of the instruction. And in that instance, if the money was coming directly out of an SPLC account, it would not have been hidden. The person receiving it would have known exactly what the source was. So I think that is yet to be completely unwound. We don't know, when they closed the bank accounts, was there still efforts being made to cloud or cloak the source of the funds that were being paid? And again, this gets back, the reality is, if you went back to the beginning of my career in the early 80s and maybe back to the beginning of your career, we gathered evidence with search warrants and interviews. And so, if documents had been burned or shredded, they were unavailable. They were gone. You didn't have it. Mm-hmm. You might have known it was there. You might have been told it was there. But when you got there, it wasn't there. Right. So, but in the digital world, nothing ever goes away. And, I was really at the end of my career when we started using things like, search warrants or grand jury subpoenas to Google for a Gmail account.
Well, there's a difference between a paper trail, right, and an electronic trail.
They get everything now.
Paper can be burned. Electronics, remain.
They get their hands on your phone because of the tracking software that's on your phone that you agree to when you accept the phone. They can track everywhere you went on every day and every time of the day because the phone is pinging the server for Google about where you're at. Mm-hmm. And so it is impossible to hide these kind of relationships in the modern digital age. Mm-hmm. So, it strikes me, this kind of case is very difficult to prove in a court of law without exchanges of information directly between the people operating this kind of program and the informants that are the operators inside the program. And if those communications between them are dirty, that's what the case is based on. The case is going to be based on acknowledgement by the SPLC that, we make a ton of money from donations with you guys doing what we're paying you to do. The ulterior motive that they would never put on their website, but is in fact confirmed by documentary evidence the government gets its hands on.
Well, Bill, I think the advantage the government's going to have is turning these informants into their informants, because these people have already shown a willingness to be compromised ethically. So they'll certainly have no qualms about jumping in with the government if it's going to keep them out of prison.
Well, particularly if you think about it on cross-examination, well, you're an informant who took money from the government to be here and testify. It's like, that's the pot calling the kettle black. You guys paid them to generate information for you.
Correct.
So, that'll be if that ever comes to pass in a courtroom, that'll be an interesting juxtaposition of cross-examination against the.
It'll be must-watch TV.
Yeah.
I can't wait. Is the establishment of fictitious bank accounts in and of itself a crime, or is this just potentially evidence of the main crime?
The particular statute that they indicted under is relatively narrow. It's just a false statement to a federally insured bank, but it has to be for the purpose of encouraging or motivating the bank to take action. So what's the purpose behind the false statements? We don't know yet what the false statements are, and that's kind of a lot of the liberal critics say, well, it doesn't even say what was false. This is
Well, I mean,
a
stuff like
defective
there were
indictment.
no corporate officers that actually performed the typical functions of an
Right.
officer in a corporation. Is that sort of thing illegal?
Well, no, that's just a shell corporation, and you have shell corporations that get used for a lot of reasons. People park assets in shell corporations that don't do any business, but they set up LLCs and they park assets in LLCs and they don't do anything. They just become the owner on paper of the asset. Yeah. These were the problems here. The problems here are several. The bank should have never opened an account in an LLC or in the name of in effect, what is a DBA? It's just a doing business as, because there were no corporate records with any state. There's no articles of incorporation. There's no LLC formation documentation. In other words, these were names that weren't really attached to anything meaningful. And banks are not allowed to open accounts in the name of DBAs. If it's a DBA, you have to open in the name of the person, the person with a Social Security number, and the Social Security number goes on the bank account for tracking purposes. And if you're going to open it in an LLC, you need the LLC's articles of incorporation and the taxpayer ID number for the LLC, again, for tracking purposes. The fact that a bank official allowed these 8 accounts to be opened in 6 different names, that bank official, I'm quite confident, doesn't work there anymore. It got fired over this.
You mean there was only the DBA attached as the name of the account? There were no individual names attached?
Correct.
Wow.
Correct.
Yeah, because I remember doing the same thing. I opened DBA accounts. I had to show that I had a DBA, but it was in my name, like you say it's supposed to be.
Exactly. This is a lot of this came in after 9/11, where they really locked down the requirements, the identification requirements to open accounts where money could be moved internationally. If money's moved internationally, the government wants to know who's moving it and where it's going. Not so much domestically, but that's why there are now very stringent requirements before a bank is allowed to open a checking account, because money can go anywhere out of a checking account in the modern age. And so if you create an LLC, then the documents supporting the creation of the LLC have to be presented to the bank if you want the account open in the name of the LLC. If it's a DBA, let's say you just have a business license under a DBA, but it's really just you, and you just operate under a trade name, the account has to be opened in your name. It can't be opened in the DBA. You can put your name on it, and then underneath saying DBA whatever, but it can't just be the DBA name, because the DBA doesn't really exist.
So were there any indication of any suspicious transaction reports ever filed by any of the banks, or has that never come up?
I actually think that might have been what kicked off the initial inquiry of the bank, was STRs filed somewhere about these transactions, because you got potentially large figure transactions out of an account that doesn't seem to connect to anything, and likely is the STR, special transaction reports, have been filed by the receiving bank. It's like, we're getting this money in large figures and we can't really make sense of it. And it's just, and the whole thing about STRs, as the suspicious transaction reports, the whole thing about them is it's part of a concept of the Bank Secrecy Act that's called Know Your Customer. In other words, banks have an obligation to understand their customers, what's normal business for them, what is odd business for them, and to report anything that's suspicious. And that relieves the bank of any obligation at that point. But a bank that engages in transactions that are suspicious without reporting it creates huge problems for them with their regulators. Somebody inside this bank, probably in response to STRs, found these accounts that have been opened in just nominee names that weren't connected to anything, and just had money going in and coming out, and said, this ain't right, and did their internal investigation. Then you see all those accounts are closed at one time, and then the government quotes the letter the SPLC sent that said these accounts were always under our control, they were always associated with us, they were only used by us. to sort of clear the whole thing up for the bank. Now the bank can document its file. But it still doesn't answer the question, why did that bank official that opened him, him, and what was he told by the SPLC people that wanted them opened? Again,
Before we move on to another topic, I think it might be worth saying just a few more words about that Charlottesville event. We mentioned that $270,000 were paid to an organizer affiliated with Unite the Right, and they're the ones who organized the Charlottesville rally. And the significance of that is it gave rise to the Fine People hoax. That's when somebody was hit by a car and Trump said there were very fine people on both sides. And the press and all his political enemies conspired to claim that Trump was referring to white supremacists, even though he had said explicitly he was not referring to white supremacists. And Joe Biden, when he ran for president, said that was the main reason he ran. He said he was not otherwise going to run. So this is the sort of effect that this organization has had, and who knows exactly, what they might have been responsible for in the way of unlawful behavior in Charlottesville, and that's just one incident.
well, and again, that's why it's important to understand that the indictment, an indictment is just a notice pleading. It's just to put the defendant on notice of the charge and some of the facts that connect to the charge. There's no obligation to put in everything the government knows. There's no obligation to put in all the charges it can support right now. We have 8 identified sources described in the indictment and just very little biographical information on what group they were with, how much they were paid, and in a couple instances, things that they did with that money. That list might be 30 people long. There might, if you were to write a comprehensive, what's called speaking indictment, where you describe, in detail and in some, serial fashion, activities of every different significant informant, maybe that goes on 50 pages once you get it all down. It's not necessary, but it's called a speaking indictment. I personally am not a big fan of them. I resisted writing speaking indictments whenever possible because, again, a speaking indictment is really just a press release. It just injects into the public conversation facts that are not necessary to be in the indictment to accomplish the purpose of the indictment. It really just, because the Department of Justice has a policy that the only facts about a case that can be commented on publicly are facts that are disclosed in court filings. Well, if you pile all the facts into the indictment, there they are. They're in a court filing, and you can stand up in a press release and talk about them for hours. Democrats love to do that. Biden administration did it. Obama administration did it.
Yeah, isn't that what the Mueller indictment was?
Mueller, yeah, Mueller did it. So I did a little bit of a comparison today. Andrew Weissman, in criticizing this indictment, has referred to it over and over again as a speaking indictment. This is not a speaking indictment. It's 14 pages long. The first, it's 14 pages long, describes 11 substantive counts, a money laundering conspiracy count, and 2 forfeiture allegations. The forfeiture allegations are 2 pages, and they're mostly technical. One of the Mueller indictments, the Russian election interference indictment, it was 48 pages long, and the first 30 pages talked about the conspiracy. Well, that's because they just wanted all that information in the press. So they put it all in the indictment. But we have no idea what evidence the government has at this point.
But what's your instinct, Bill? I get the feeling that even though we don't know the evidence yet, I think that you believe this organization is in deep doo-doo. Am I right to be detecting that vibe from you?
I think the allegations of the indictment state a crime. There's no shortcoming there in terms of the allegations of the indictment. The issues will be the extent of the duty to disclose as a 501c3. That's kind of a legal issue that still has to be sorted out. Not a lot of case law on this. This is kind of a question of a unique question with, certainly there's never been an organization like the SPLC in this position as a defendant in a criminal case. So that remains to be seen. The other thing that remains to be seen is this case is filed in the Middle District of Alabama in Montgomery. You're going to have a racially mixed jury. And, will a racially mixed jury react badly to this effort against a historic civil rights organization that, I think there's no way to call into question the fact that in its early years, maybe for a decade or more, it did exactly what it claims to have done. It went after racist organizations in the South. Is it still doing that in the 2020s? That's the question. Or has it become just essentially a never-ending, supply of donor money to make comfortable everybody that works for it?
They're going to be the Tommy Kays of the present day.
Correct. Yep.
All right, well, we want to ask you about a recent Supreme Court case, DC versus RW. But before we do, just in case some of the members of the audience aren't familiar with what I refer to as the fine people hoax, let me show some video clips of that situation.
Talking about the neo-Nazis and the white nationalists, because they should be condemned totally. But you had many people in that group other than neo-Nazis and white nationalists, okay? I've condemned neo-Nazis. I've condemned many different groups, but not all of those people were neo-Nazis, believe me. Not all of those people were white supremacists. You also had people that were very fine people on both sides. You had people in that group, excuse me, I saw the same pictures as you did.
Those are the receipts. Why doesn't President Trump condemn racism? His own words and actions tell you why. He's a racist.
Okay, I'm being told we have it. Thank you. Run it, please.
Excuse me, to protest. Excuse me, they didn't put themselves down as you. And you had some very bad people in that group. But you also had people that were very fine people on both sides.
That was President Trump saying that very fine people were marching alongside neo-Nazis and skinheads and white supremacists, people who had chanted Jews will not. Yes, those people, the anti-Semites in Charlottesville.
They were tapping into the deep and dark vein of what's known today as replacement theory. Now, most people watching that would be outraged. The former president said this.
They showed up in Charlottesville. Excuse me, to protest. Excuse me, they didn't put themselves down as you. And you had some very bad people in that group. But you also had people that were very fine people on both sides.
Very fine people among Americans that night chanting Nazi slogans.
Man who has often struggled to unequivocally denounce white supremacists.
They showed up in Charlottesville. Excuse me, to protest. Excuse me, they didn't put themselves down as you. And you had some very bad people in that group. But you also had people that were very fine people on both sides.
Those words have power. They have meaning. And when Donald Trump speaks, the world listens. Neo-Nazis and white supremacists certainly listen. So why can't he denounce them? Why can't he reject their support?
Well, you heard him explicitly renounce them, yet that's how they played it. And that's what the Southern Poverty Law Center funded. All right, let's talk about that Supreme Court case. This was so crazy, it blew my mind so much, I'm thinking there may be something to it I just don't understand. This was a case where a radio dispatcher said there's a report that somebody called in about a suspicious car, suspicious vehicle at a specific location. And police officers responded to that location, and they saw two people flee from the car. And then while one of the doors was still open, the driver started to back up. And I guess it was the appeals court ruled that the fact that there was a radio call and that people fled was considered irrelevant. And so therefore the police did not have reasonable suspicion to stop these people. Am I getting this right? And if that's not reasonable suspicion, what is? How can the police ever stop somebody?
Well, yeah, you got the basic facts, right, and there's no doubt that the view of the, I think this was a 7-2 decision. The view of the Supreme Court was clearly that the appeals court in the District of Columbia got this wrong. So just so we understand, there's a little bit of odd arrangement of the court system there. This is an appeal from what's called the District of Columbia Court of Appeals out of the Superior Court of the District of Columbia. These are sort of local courts that exist in the district to enforce local law. So in the same way a burglary might be prosecuted in Los Angeles, in these courts, a burglary is prosecuted in the District of Columbia. There's a parallel two courts in the District of Columbia, which is the U.S. District Court for the District of Columbia and the D.C. Circuit Court of Appeals. That's where federal cases, federal crimes, like the SPLC case, those would be in sort of that parallel U.S. District Court. This is out of the Superior Court. So it's more street crime kind of stuff. More the same kinds of crimes that would be prosecuted in any city, as opposed to mail fraud, bank fraud, wire fraud, money laundering, that kind of stuff. So what happened here, these are juveniles. This case initially begins in juvenile court because the RW, the subject of this case, was a judged delinquent. He wasn't guilty of a crime. He was a judged delinquent. That means he's 17 or younger. And there's nothing controversial about the case law the Supreme Court cites here. You know, that yes, these are all factors that warrant an officer to have reasonable suspicion. When he has reasonable suspicion, that means he can detain the individual while he tries to figure out what's going on. During that brief detention, which is authorized by law, if the officer develops probable cause that a crime has been committed, then he can arrest. It's like a three-step process. I show up, I see something, speaking as an officer. I show up, I see something. My experience and the collection of circumstances lead me to believe that possible criminal activity is afoot. Therefore, I detain the person that is the focus of my attention, and I explore further whether, in fact, there is criminal activity afoot. If I conclude there is, then I can arrest them. Okay. What happened here, and I think this is the only reason the court took this case, is the appellate court, in reviewing the underlying, the trial court, the defendant was convicted, so to speak. Again, we're talking about a juvenile. The conviction is not the word you use. You use the phrase adjudicated delinquent. But just for simplicity's sake, I'm going to say the defendant's convicted in the trial court. Goes up to the Court of Appeal. The Court of Appeal says, well, yes, we understand this reasonable suspicion test, and we see 4 factors here identified by the officer before he tells the defendant to put his hands up. Once he tells the defendant to put his hands up, he's detaining him. So the question is, what did he know before he told the defendant to put his hands up that justified detaining him? And the 4 factors are the call, approaching a car that was consistent with the call, having 2 occupants of the car jump out and take off running, and then having the driver begin to back the car out of the parking space with the door open, which wouldn't necessarily do unless you're in a hurry to get away from any inquiry by the police officer who's just arrived. What happened was the appellate court judge sort of took those 4 factors in isolation without considering them as kind of a total package, carved them up into 4 slices, and then evaluated them individually. And then the appellate court said, well, the fact that you get a call, that doesn't really tell you anything about whether or not there's anything to be suspicious about. The person making the call might just be a crackpot. You don't know until you get there. So the fact that there's a call, we set that one aside. It's not relevant without anything else. And then the fact that 2 people got out and run, the Supreme Court has recognized over and over again that, under those circumstances, and it's 2 o'clock in the morning. That's the other thing. We got youthful offenders, so to speak, at 2 o'clock in the morning, jumping out of a car and running away from the police. For whatever reason, the appellate court judge kind of didn't see anything suspicious there and set it aside. So in fact, what the court did is it took half of the 4 factors, 2 of them, pushed them aside and said, yeah, and these 2 remaining factors, they don't amount to reasonable suspicion. And this is contrary to the way the Supreme Court has long established for lower courts how to evaluate reasonable suspicion. And I think what the court was concerned with and why it took this case and reversed it summarily, didn't even have an argument on this, just took the briefing and reversed it summarily, is because the appellate court in D.C. was beginning to slide in this direction. There have been other cases where it was beginning to slide off on this carve them up and evaluate them individually, and the court basically stepped in and said, no, that's not the way you're supposed to do it. We're going to make it clear that that approach is not appropriate, and do your job right from now on. I don't think there's anything more to it than that. They were just trying to nip it in the bud, so to speak. Stop this approach before it goes too much further because it's not consistent with prior Supreme Court decisions.
Bill, I have
Greg,
one. I'm sorry. Go ahead, Jeff.
I just want to ask, like, when you were a cop, if you got this kind of a call, suspicious vehicle, and you show up to the exact spot that was reported where it's suspicious, and you saw two people fleeing the car, and then the driver trying to drive away with the car doors still open, would you ask yourself, well, maybe I don't have enough reasonable suspicion to stop? Would that even ever enter your mind?
If enough cars showed up at the same time, both of those people that fled would be chased and detained.
Right.
But my question is, who in D.C. in the bar is deciding this is like the hill we want to die on? Like this case, a juvenile adjudication is so legally impactful that they feel compelled to appeal it. I just don't understand. Not so much, I guess, the motivation, but how do they have the resources to pursue something that is an everyday probably occurrence?
Well, this was the juvenile was convicted in the district court, so he had a right to appeal, and he's got.
I understand, but I'm sure he doesn't have the financial resources to appeal.
Well, he's got appointed counsel. He's a right to counsel if he can't afford one. One's appointed for him.
No, I understand, but I've seen the people that represent these people, and they usually are juggling like 150 cases at one time.
Sure, but they got a favorable panel in that appellate court that said, yeah, we think you're being treated unfairly. We're going to take care of this.
Okay. The other question is, and I know it's not probably the right case law, but Terry versus Ohio.
It's exactly what it is. It's a Terry stop.
Okay, I was trying to figure out how come I didn't see it cited in the court case. They did mention the totality of the circumstances, but that I thought was sort of part and parcel of the Terry versus Ohio case.
Well, there was a more recent one, and this is the one they relied on, 2002 case, Arvizu. They all go back to Terry. Terry is the foundational case that established the right of an officer to detain somebody briefly for a Terry stop. A brief investigatory detention to just determine if there's anything that requires further police inquiry.
Because of the fact that a police officer can articulate what they see as suspicious behavior, which maybe to a lay person they may not recognize, right?
Right. Short of probable cause, right? And it's based on training and experience and all that other stuff that a layman wouldn't necessarily have. Familiarity with the location. It's a drug corner. All the kind of things that would factor into it that wouldn't obviously be or wouldn't be obvious to a layman. But this Arvizu case from 2002 was essentially an updated case, exactly like Terry, that kind of went into this. We don't carve them up into individual slices and review the slices separate and apart. It's a collective. We look at all the slices. Some may be more important than others, but they all kind of go into a collective mix.
Okay.
What should we think about the two justices, one of whom I know is Jackson, I don't know who the other one was, who dissented?
I think it was Sotomayor.
Sotomayor would have denied cert, so she wouldn't have even considered the case. So she wasn't passing on the judgment reached by the majority. She just would not have considered the case. Jackson essentially had the same view. It's like, why are we doing this? Why are we fly-specking, so to speak? She's talking. The judge uses the judge below used the word. Let me find it here because they both made a point of it. Where's it at? there's a specific word that the majority pointed out. Jackson said, yeah, I shouldn't have used that word, but we're into the semantics now, and why are we excise? The court below said, I'm excising the dispatch and I'm excising the fact that 2 people ran away. And I'm only considering the remaining 2 factors. The driver, see, the 2 people running away, the court said, well, that's not the defendant. So why are 2 other people running away relevant to what the defendant did? The defendant did back the car out with the back door open, and the defendant was in the car at 2 o'clock in the morning. I don't know if DC has curfew, but a circumstance, a young person like that being out in the car at 2 o'clock in the morning.
Yep.
So Jackson's basically saying, yeah, I probably shouldn't have used the word excise. Could have used a better word. But why is the Supreme Court dealing with word usage by a lower court when it's not what our summary authority is normally used for? But that's my point. That goes back to my point. I think the other justices said, we're going to stop this before it gets going any further because they're going down the wrong path. And this was a very simple, easy case to do that.
They were trending away from totality of the circumstances, right? Okay.
All right. Before we call it a show, I'd like to ask you both about the shooting that occurred a few nights ago at the White House Correspondents' Dinner. I'm wondering if you have any reaction to all these people who are insisting that it was some kind of false flag or that it was staged, although I haven't heard anybody explain any particular theory as to what they think really happened or what really didn't happen that differs from what we've been led to believe, yet they're insisting it was staged. I'm wondering if you have any reaction to that, and also what you think about the security and the way the Secret Service handled the situation.
Go ahead, Bill. You're our guest.
It's like it's hard to conceive a staged assassination attempt that leaves the assassin alive to tell all about how it was staged. It's like, it's idiotic. I mean,
how much money would you have to pay someone to go to prison for the rest of their life
and never say a word? And never say a word about how it was all a setup and that they were brought in to basically be the patsy.
Right. I mean, he's likely to die in prison. And how much money could you possibly pay someone to convince him to do that?
Right. All the conspiracy theories about the Kennedy assassination focus on the fact that Jack Ruby shot him and killed him. And then, you couldn't get answers from the guy who was supposedly the patsy to kill Kennedy because he's dead. You don't leave the patsy alive to talk about the scheme that he agreed to participate in. So it's just dumb.
Yeah. All right, so it's ridiculous. I think so too. Also, like I said, they have no theory. They're just saying it was staged, as if that is somehow meaningful, but it's really meaningless unless you can explain what you think happened.
Yeah, and look at the information they've just developed in, roughly they had developed in 18 or 24 hours, about his travel from, California to DC. He stayed in the hotel 2 nights before this happened. What I thought was really interesting, and I just kind of chuckled over this, is he stays 2 nights. He had reserved the room for a 3rd night. Did he think he was going to go back to his room?
That's funny.
He was going to need it a 3rd night after he went in and shot up the White House Correspondents' Dinner.
Maybe so he wouldn't look suspicious. Maybe he was thinking,
yeah. So, but
what about the way the Secret Service handled the situation and the degree of security that was there?
Yeah, I think there's a lot of questions left to be answered. I'm not sure you could. The guy didn't get close. A lot. You could. Experts can look at the video and say, well, that guy did something wrong, and that guy did something wrong, and that guy did something wrong. But the bottom line is, if you know the layout of the Capitol Hilton, where they got him, and where the ballroom was, he was nowhere close to the ballroom. he had lots of barriers. He basically got caught at the first hurdle he had to overcome, and there were several hurdles after that he would have to overcome.
Well, but the only thing is, Bill, he was one flight above and one staircase, away. So,
but it wasn't open. He didn't have just like a free run. If after he got past the first guys that he encountered, it wasn't like there was nothing left to encounter. There were still layers of security.
Yeah, I understand. I think that the Secret Service always performs admirably, but I think that their site security planning leaves something to be desired still.
Yeah, I'm really kind of become. Imagine this. The Beslan school takeover, where you had 10 Islamic terrorists show up with automatic weapons, or the Charlie Hebdo, the assault on the offices of Charlie Hebdo in Paris, or the Paris Opera House attack, where you had 10 or 12 armed terrorists with automatic weapons get inside an opera house and kill 90 people. Imagine if there had been a coordinated effort by 10 or more armed individuals with automatic weapons, which you can get automatic weapons in the United States.
I posted this specifically on LinkedIn a couple of days ago, and my scenario was, 4 two-man teams, of Middle Eastern origins, basically
with training, knowing what they're doing.
Correct. Wearing ballistic vests, shoulder weapons, kitted out. Handguns, maybe grenades, and if they just piled out of that elevator en masse and dispersed into 4 two-man teams, they would have overwhelmed those security checkpoints. Now, I'm not saying they would have been successful in assassinating the president or the vice president, but they would have inflicted enough carnage in that venue that we would have been talking about this like it was 9/11.
Exactly. And consider the weaknesses of having it at a hotel where you got 1,000 or more just hotel guests, have nothing to do with the event. This guy was able to get a Mossberg shotgun into the hotel in his luggage. Hotels don't screen luggage.
Overseas they do, but not in the United States. And if you look back at the Las Vegas 2017 shooting at Mandalay Bay, that guy was able to bring in an arsenal by himself, right?
Right.
Thousands of rounds of ammunition, multiple shoulder weapons, and the same could have been done here. But the problem is, if they had 8 or 10 people that were all like-minded and had some training, there could have been a huge amount of damage created by those.
Yeah, they get 8 different rooms. They make reservations on different days. There's no reason to associate them with each other. They're making the reservation at the hotel, not with the Secret Service.
Correct.
And
we should also
aware.
point out that trains don't check for weapons, and this guy took a train from California rather than flying, and now we have some of the gun control crowd saying, "Oh, we should check for weapons on trains." Are they just being opportunistic, or is there?
Yeah, but he could have driven from California if he was that committed.
Well, then obviously we should check cars too at every corner.
Well, wait, you can get a gun on an airplane. It has to be in your checked luggage.
Yeah.
You can I've taken long rifles on airplanes. You just have to put it in your checked luggage. You can't have it in the cabin.
Oh. So then why did he take a train? Do you get put on lists or something if it's checked in your luggage?
Well, you have to do paperwork. You have to disclose to the airline that you have it and it's in your checked luggage. So that may go into some system.
Plus I think he was brighter than the average guy and was probably worried about flagging himself by doing that. With this way, on the train, he has to file no paperwork and just brings it with him.
Right.
Yeah. Plus, it's his last chance to see half the country before he spends the rest of his life in prison. So, want to take advantage of that.
I never thought of that.
I've been on that train ride. I like that area of the country. The high deserts in Nevada and Colorado, or into Utah and Colorado and Wyoming, and
he went to Chicago first, and then he transferred into D.C. Is that right?
Right. Had to change trains. Yep.
Yeah.
All right. Well, I'll be looking for your description of the travel in your manifesto. I like that word manifesto, by the way. I don't know who decides that something is a manifesto as opposed to just a statement or an email or something.
Or a manifest.
Yeah.
If Link factors into it, I write like 3 of them a week.
Well, yeah. I guess it's generally not considered good news if anybody describes what you wrote as a manifesto. All right, Bill, thanks a lot. And I want to tell everybody to check out your Substack. You have what you call a law splainer about the Southern Poverty Law Center indictment there. That's very detailed and always great content there. One of the best Substacks going. Shipwreckedcrew.substack.com. And people can follow you on X at Shipwreckedcrew. Thank you so much for spending some time with us today.
Great to be with you again.
Thank you, Bill. I enjoyed it.
Bye-bye.
And we are live now. Sorry. Oh, sorry. That was just a little audio left on that recording. Okay, boy, you and Shipwreck Crew enlightened me. First, you. And I want to tell people about your LinkedIn. Let me get that on here. You can follow Greg on LinkedIn at you are GB Dillon on LinkedIn. And Dillon is Dillon, but don't tell Bob. He doesn't spell it like that. GB Dillon. No, you showed me your devious criminal mind to be thinking that way, but you're absolutely right. Essentially, you're saying, just a few more people, if they were well armed, could have gotten past that point where the one guy did, and imagine what they could have done. That's sort of the risk all the time when you're in a hotel, but I guess it's pretty rare for the president, vice president, and a good part of the cabinet and all their spouses to be in a hotel at the same time, isn't it? Maybe the election night they are, but that's about it, right?
Well, the interview or the report that Trace Gallagher on Fox News when I cited in my LinkedIn interview, my LinkedIn article, he had said, when he travels internationally, he says, you don't get into a hotel with any bags or any luggage without it being X-rayed and screened. He said, even if you go out shopping and come back with a shopping bag, they still want to see what's inside the shopping bag.
Well, you say that like maybe we should do that here, or maybe just if it's a special situation, like if the president's going to be at the hotel.
Well, yeah, absolutely. If there's going to,
I don't think travelers would appreciate your thought here if you're talking about doing it all the time.
No, I understand. I understand, but apparently overseas that's routinely done, and that's something that would have prevented the Las Vegas Mandalay Bay shooting. But I understand it logistically.
Yeah, but hold on. Maybe diminish the likelihood, but I don't think they're going to search people every time they come in and out. So imagine if they check in, they don't have guns on them then, but somewhere in the middle of their stay, they can get the guns.
No, I understand. Yeah. But if you ever see the footage from the Mandalay Bay, I mean, he had a luggage cart with boxes and rifle cases that he was just bringing in directly to his room.
Right.
I mean, it was apparent.
Maybe their guitar. He's in a rock band. Guitars, microphones. You need a lot of equipment. Well, seriously, it was really good thought that you had there on what could have happened, and now I know you could be a great criminal if you wanted to be. So there you can find Greg on LinkedIn, linkedin.com/in/GB Dillon. Why do they have to? They don't have to, is the point. They put IN in the middle of it. And if you don't have that IN there, it won't work.
I guess because LinkedIn, I don't know. That's their little thing.
That doesn't explain why they do it. No. All right. I'm boycott LinkedIn because of that. I'm very upset. Now, also, I learned from Bill tonight, I'm sort of embarrassed to say because it seems sort of obvious now that he said it. The fact that they didn't shoot and kill the suspect indicates it probably wasn't a setup because they wouldn't want the guy they set up to be alive to spill the beans, right?
Yeah, I mean, it's interesting that out of the 4 assassination attempts, only one person's ever been killed.
Yeah. See, so the people who were saying that it was, staged were pointing out different irregularities. One of them was that, but they said it in reverse. They're saying, oh, because they didn't shoot him. In other words, it's protocol usually for the Secret Service to shoot somebody in a situation like that. And they were saying, so therefore, that was one of the little dots that they were pretending connected, which don't really connect. But on the other hand, I think, aren't they right that normally a person in that situation would have been shot?
Yeah, I'm not sure what happened. I mean, it sounds like at some point he stumbled and fell to the ground. Perhaps at that point he lost his weapon and they realized that they did not have to, discharge their weapons to neutralize the threat, that he was no longer a threat. I don't know. I mean, that seems to be something that has not been addressed yet, is how they actually got him into custody, because you see him on the ground with no shirt. Something happened because he had a shirt when he ran through the checkpoint. So there had to be some sort of a physical struggle.
Why are you assuming it was the Secret Service who tackled him? Maybe it was somebody else in the hotel who did it.
Well, that's the whole thing. I'm just surprised there's not more information that's forthcoming. Yeah.
All right. It was not Kash Patel. I think we can safely assume it was not him. All right. Let's do a little Has It Happened to Greg, and then we'll call it a night. All right, Greg, there's a reason I said to you, hey, don't assume that it was one of the cops who did it. You never know who might have gotten into it. And here is some documentary evidence that it could be somebody besides the government. Hold on, is that the right? What am I showing here? What are we looking at?
Is Bill Shipley the guy who does the tackling?
No, he's not. I don't even see where that is to get rid of it. What's going on here? Hold on. Okay. Now I see what's going on.
Air control copies.
Okay, speeds are almost 90. Yeah, just 401. 401 DI indicator. DI indicator. He's on the passenger side. He's running. He's already running eastbound. Running eastbound. Gonna be eastbound DI at Frontier. Looks like some citizens are actually trying to. A citizen actually pulled over and grabbed him right now. So, Decatur and Frontier.
And I believe you would agree that we can call a citizen's arrest.
Yeah. Well done.
I knew I would find some example of that being a thing. Now, I guess if he hurt the person that he arrested, he could be sued and be liable for it. But it didn't look like he did anything that it caused damages, right? Because that is the risk if a citizen gets involved, right?
Sure. Yeah. The citizen can get hurt. The criminal can be hurt. Yeah.
Well, has it happened to Greg? Have you ever been involved in apprehending somebody when a citizen jumped in to get involved?
I was the citizen one time.
Oh, well, that's almost the same thing. What happened?
I many years ago when I was in college, I was a big brother in the Big Brothers Big Sisters program. And I was assigned a young black child that was 6 years old, a single mom family. And he lived in a housing project in New Haven, and it was a very bad housing project. Being young and stupid, I used to drive there just about every weekend and pick Randy up and take him in my car, and everyone would just kind of watch and look, but nobody ever challenged me or confronted me. And for years, we would go out and spend the afternoon, whatever, playing basketball or take them to the Y for swim lessons or whatever. And when I had him till he was 12. Then eventually I left to go to the FBI. And when I came back in 1990, I wanted to, out of curiosity, see if he was still around. And I did some investigation, and I contacted a New Haven police sergeant that worked in that housing project, and he said the family was still there. He left a note on the door. Randy called me. I made we agreed to meet up. I would pick him up.
And how old is he at this point?
Oh, he was in his 20s at this point, maybe even close to 30.
Okay.
I went to the housing project, and on my way into the housing project, there was an obvious stolen car that was doing donuts on the ball field adjacent to the projects and just destroying the baseball field. And this is before cell phones. So I drove to the district station, reported the damage in the description of the stolen car and the driver, and then drove back to the housing project to go see Randy. And when I was walking to his building, I see the police cars chasing the stolen car. And like a minute later, I see a young man looking very much like the driver of that stolen car running behind the buildings. And no one is chasing him yet. So I decided that I would step in. And I tackled him violently and broke his collarbone and shoulder. And then the police arrived and took him into custody. A crowd formed, and I had to leave because it was starting to get a little dicey. Left, went to a payphone, called Randy, told him what had happened. He said he saw it.
Oh, I thought you were going to tell me that was Randy.
No.
Right.
And then Randy walked a few blocks to meet me at my car, and then we went out and had lunch.
Oh, good. I'm glad to hear that Randy, was on the straight and narrow after being mentored by you. That would be terrible if he turned out to be the bad guy. So were there any legal repercussions that you suffered as a result of you injuring the kid or the guy, whatever? I don't know. No?
Yeah, no, I think he was a juvenile at that time. And no, they picked him up and took him to the hospital, and that was the last I heard of it.
All right. Now, the Big Brother organization that handled this situation with you and Randy, they didn't care that you were a white supremacist, or they weren't able to find out?
No, I passed all the background investigations, and him and I had a nice 6-year relationship.
That's very nice. Good for you. You're a good man. All right. Let's take a look at another one. How old were you when you retired?
I was 52.
52. Okay. So you're not a young man anymore. I guess you would agree you're not in your prime physically at that point, but you're still in good shape, right? You could have gone on many more years if you wanted to.
Yes.
Okay. Here is somebody who I would say does not meet that description. Here is somebody who maybe should have retired. Take a look and see if you agree.
Okay.
And the chase is on. First, let's try to get the bike. All right, here he goes. He's in pursuit, hot pursuit.
He looks like Frankenstein's monster.
And he allows the kid to get back to his bike. That's cool. Those last few little jogging steps were very half-hearted. I don't think he really thought he was going to catch him.
No, I think he was trying to keep his balance at that point.
I don't like to make fun of the elderly, especially since I'm heading there. The rumor is we all are. On the other hand, you got to face reality. And what do you say?
Well,
I mean, chances are there are other situations in which his physical diminishment would have also been quite relevant, don't you think?
he belongs inside. He needs to become a house cat, and they have to find a place to put him so that he's out of harm's way.
Right. All right. Let's look at one more, and I don't know if I should say, has it happened to Greg? No, it didn't happen to you. That you were too old. But have you ever been involved in a situation where other members of the police department, whom you were kind of relying on in that particular situation, weren't up to snuff physically?
Yeah.
Like what happened?
Foot chases.
Uh-huh.
I mean, it wasn't common, but once in a while, if we had to do an outdoor surveillance for a fugitive and we weren't able to get him, in a car or a building, they would flee on foot. And usually, like within the first 2 minutes, only the fit, officers are in it, and the rest are just standing there watching you run off into the distance.
And do you bitch about it later, or does that just make the situation worse?
It depends on your relationship. Like it happened one time with me and a few of the inspectors I was with. So I can be a little more judgmental when they're my team than when you're working with another department or another agency. It's not really your place to start questioning people's fitness for the job. But as far as the people that were on my team, I asked them to reevaluate their physical standards.
Yeah, it seems like it would be a little awkward.
Yeah.
You fat fuck. Or now you would probably find more diplomatic words than that. Right? I assume. All right, let's look at one more.
We're good. And they're going to ram. Okay, you ram the officers there. Now they're going to come out with guns drawn. We're going to keep a wide shot. They have their guns drawn on him. He's reaching back into the car. That's never good. He pulled something out. He's going after the officer there, and he's going to fight with the officer. Wow, look at that. All the officers are going to come on him. They're going to get him in custody here. But what a dangerous situation for those CHP officers.
Sky 5 capturing the moment the suspect walked up to a CHP officer and began fighting with him before being tackled to the ground. Officers worked together to hogtie that suspect before taking him into custody. It all started on the southbound 405 near the 105 interchange in El Segundo. At one point, that suspect stepped out of the vehicle, appearing to yell at the officers before driving away again. He eventually drove over a spike strip near Seal Beach. The suspect was wanted for driving through a traffic break and failing to yield.
I don't know whether we would attribute it to adrenaline or just being crazy or being under the influence of something. But obviously, when there are cops all over the place and you're finally caught and you get out, the chances are not great that you will fight your way out of it.
No, that's almost a death wish there, because I thought it was going to result in a fatal officer-involved shooting, but he's lucky that it did not.
Yeah. What would you attribute it to? I guess you can't really tell, but
impairment of some sort. Whether it's drugs or alcohol or both, or mental illness. I mean, it's so hard to say, but the response is certainly inappropriate for the circumstances.
Yeah. What do you think is more unlikely, that guy would fight his way out of it, or that the shooter in Washington at that event the other night would need that third night that he reserved at the hotel for the following night?
Well, you made a good point, though. You made a good point when you said, not to arouse suspicion, he might have booked for one extra night. And, there could be something to that. I mean, what
I was thinking of is, it's like if you go on a flight and you don't take any luggage with you, people look at you like, what's going on with this guy? Yeah.
Yeah, no, I agree. When you said it, it made perfect sense. I'm not quite sure that was, possibly for the event, you had to book 3 nights. I mean, there's also something weird like that where they wouldn't take any reservations for less than 3 nights. I don't know.
Mm-hmm. That's why when I travel with no bags, that I bring a little something and I stuff it with a notebook paper, just so that it doesn't arouse suspicion on my way to perpetrate my horrible crimes. All right. Well, LinkedIn is the place to find Greg and his theory on how the world could have come to an end, more or less, if it were a whole bunch of well-trained criminals instead of that one guy down in Washington. And you can find that at linkedin.com/in/GBDillon. And then there's Greg's book, The Thin Blue Lie, not The Thin Blue Line. Nobody would ever say that, would they?
Oh, happens all the time.
Oh, it does. Okay.
In fact, if you Google Amazon and you type in thin blue lie, it will automatically correct you to thin blue line.
Oh, that's not good. No. Amazon's working against you.
Yeah.
They say, why do you want to buy that book? Instead, go buy something else.
But it's a book they carry, so I don't know why it works like that, but it does.
But do they also have something called Thin Blue Line?
Yeah.
Oh, okay. Well, then it's not totally crazy. Okay. All right. Thanks, Greg, and thanks to our beloved audience, and thanks to Bill Shipley, Shipwrecked Crew. Is he one of our? Are we great for having guests like this, or what?
Yeah.
Let's give ourselves a round of applause, and also thanks to Bill for joining us. He's
a rock star in legal circles, definitely.
Absolutely. All right. Thanks a lot, Greg. Thanks to our beloved audience. See you next week, everybody.